Good morning and welcome to The Appeal Live, a co-production of Now This and The Appeal. I'm Emily Galvan-Almanza, and today we're going to be talking about one of the most harmful yet pervasive narratives in the criminal legal system and how a new effort in Oregon is seeking to confront it. So if you're like most people, and I'm going to be real, most prosecutors, you might look at the criminal legal system as being comprised of two distinct categories of people. There's like the perpetrators of crime, bad guys, and then there's like the victims of the survivors of crime, the good guys. And this is a super convenient view of the world because it places people who are complicated into boxes which are not complicated. There are good people and bad people, and those who deserve sympathy and compassion and those who don't. And that makes carrying out the really ham-fisted, oppressive work of a punishment bureaucracy much easier to do. But if we are going to face reality, the reality is that the categories are grossly oversimplified and people don't fit into boxes. And in many cases, these categories are meaningless because it turns out that the system is filled with people who are both survivors of crime and perhaps perpetrators of harm in their own right. And today's survivor might be tomorrow's perpetrator, and vice versa, because humans are complicated and life is long. So the criminal legal system's total refusal to acknowledge this reality is painfully evident in its handling of crimes committed by people who are also survivors of abuse. This trend hits women especially hard. Nearly half of all incarcerated women are survivors of physical or sexual violence. And among the 230,000 incarcerated women and girls in the United States, at least 30% of those serving time on murder or manslaughter charges were protecting themselves or a loved one from violence. This is according to research for The Appeal. Now, as a public defender, I have personal experience. I've had to fight on multiple occasions for women who prosecutors were trying to incarcerate because they fought back against their abusers. Some had even been arrested for fighting back while being assaulted themselves. And for too long, the legal system has completely ignored the role of abuse in criminal behavior and meted out extreme punishments to people who may have been, whether or not fighting back actively physically against an abuser, but also people who might have been forced into criminal activity by an abusive partner or family member, or who may have been acting to save their own lives or dealing with extreme forms of coercion. So a new bill in Oregon would seek to confront this dynamic by granting the courts the ability to shorten sentences for people who are survivors of domestic violence, when that abuse was a contributing factor to the crime, and when the presumptive or mandatory sentence would be unduly harsh in light of the violence they suffered. Additionally, the bill would allow survivors of domestic violence who are currently incarcerated to petition for resentencing. For more now on this new legislation and the effort to acknowledge the role abuse plays in criminal behavior, I am joined by State Representative Anna Williams and Julia Yoshimoto, Project Director of the Women's Justice Project. Thank you all so much for being here.
Thank you for having us.
Thank you for having us.
Yeah, it's great to have you. But I think we need to sort of take a step back and talk about the system the way it is now before you change it. So Julia, I'd like to start with you to talk about the scope of this issue in Oregon. How pervasive is domestic abuse, and how heavily does it result in other crimes in your state, especially among women?
I think that we don't really have very good data to say exactly how prevalent it is, but we know that there is a high percentage of women who are incarcerated in Oregon's prisons who say that they have a history of domestic violence or other types of trauma, sexual assault. We did a survey in 2017 and 2018 of about 140 women. And 65% of the women who are incarcerated that participated in the survey said that at the time of the crime or the time of their arrest, they were in an abusive relationship. And 44% of the women who participated in the survey said that at the time of the crime, that the relationship contributed to the commission of their crime and to their arrest. And when I talk to domestic violence advocates and others who work with women who are survivors in Oregon's prisons, they say that these numbers their guess is that it's underrepresentative of the prevalence in our prisons.
So Representative Williams, thinking about the scale that we're talking about here, which is really striking, can you talk to us about your bill, HB 2825, and tell us exactly what it would do and why you felt compelled to take action on this issue?
So House Bill 2825 is a bill that would both allow at the time of defense for information to be presented regarding how the domestic violence relationship contributed to the commission of the crime, and then give the judge, actually require the judge to consider that information when they're determining the sentence. Because of Oregon's Measure 11, there are mandatory minimum sentences defined for certain crimes that the judges don't have an option to give a lighter sentence than those mandatory minimums. So this bill would actually allow judges to give a lighter sentence on those Measure 11 crimes if domestic violence was a contributing factor, a significant contributing factor to the commission of the crime. And as you mentioned earlier, it would allow people who are already incarcerated for those types of crimes to submit a petition to describe how the domestic violence they were experiencing at the time of the crime was a significant contributing factor, and then pair them up with a public defender so that they could petition the court for redress and obtain a lighter sentence if that's what is appropriate given the details of the case. So it not only improves the defense process as we're going through at the initial time of sentencing, but then it also allows people who maybe needed some distance and some space and potentially to connect with other survivors as they're getting services once they're incarcerated to understand the dynamics of violence and how that did really contribute to the decisions that they were making and their lack of choice in making those decisions around committing the crime. So because sometimes it's impossible to put it into words at the time of the defense. So giving somebody some time to process and put words to it so that they can actually articulate it to the judge. We really sort of need both of those pieces, the upfront and then the post-sentencing option as well.
So thinking for a second about what I imagine prosecutors want versus what they actually want. I sort of imagine a world in which we all want as few people as possible to be locked in cages and as many people as possible to be healing and returned to their home and their family and their community. Your bill seems to be nuanced and not by any means extreme. It does not seem like you are flinging open the prison doors here. But the District Attorneys Association of Oregon has come out against your bill. Why would they not want judges to consider information about a survivor's experience?
I mean, frankly, I can't speak on their behalf, but the evidence that they presented at the hearing was really that they don't feel like we should be departing from Measure 11 sentencing whatsoever, that's something that the voters passed and we should leave it the way it is. I think that we know a lot more about trauma and how it impacts the commission of crimes now almost 25 years since that bill was passed or since that measure was passed at the ballot. We already did some Measure 11 reform in the last session relating to juvenile defendants. And I think Oregon's criminal justice community is waking up to the fact that in order to rehabilitate people and make them productive members of society, we have to actually account for the trauma that they've experienced as they go through the criminal justice system and the trauma that they experienced prior to entering the system as well.
So, Julia, if I understand correctly, women's groups and survivors' rights groups are behind this bill. But I want to ask you about one particular side of the ODAA response here, which is something that surprised me. Even though women's groups and survivors groups are backing the bill, ODAA is claiming they are speaking for survivors in coming out against it. What's going on with that?
My take on what I heard at the hearing and the position that they're taking is that the prosecutors in this state are very used to controlling how the case goes. They're used to having all the power in terms of how cases are resolved. And they're taking the position that, this is already taken into account, while at the same time saying that this is going to require more investigation. I think it really just boils down to they're used to having all the power and control in the conversation and in how cases are resolved. And this is something that strikes at that gives power to the judges to use their discretion to look at the situation of the crime, to look at the circumstances of the defendant and make a different decision.
I'm going to ask an impossible question, which is to either of you, having watched this hearing and seen how it went, do either of you have a sense of how judges feel about this legislation? Are judges eager to use this information? Are they hesitant to have more ambiguity? What's the vibe from the bench?
I don't know exactly what judges across the state are thinking about this. I do know that I've talked to a number of women who have gone through their sentences where domestic violence was not taken into account, the circumstances were not considered, and they recall judges saying to them, my hands are tied. I don't want to send you to prison for this amount of time. But there's nothing that I can do about it. This is the way the mandatory minimum sentencing works. This is the way the system works. And the women recall that, they remember that. And I think that this is something that we have heard from judges when it comes to Measure 11. We have heard judges say generally that, they wish that they could have more discretion when it comes to that mandatory minimum sentences. We have judges speaking out on Measure 11 saying that it does lead to unjust, unfair sentencing practices.
So Representative Williams, recent polling from Data for Progress in the Lab, which is a project of the appeal, found that 70% of likely voters, including solid majorities of every party affiliation, so a bipartisan majority, support legislation that would allow courts to impose shorter sentences, and including allowing courts to resentence people who are already sentenced for people who are survivors of domestic violence when abuse was a contributing factor. 70% is really robust. Does that number surprise you? And what do you think that says about the sort of tough on crime trend that we saw for so long in prior decades?
Frankly, it doesn't surprise me because I think, like I mentioned earlier, we've just learned so much in the last 25 years about how trauma impacts the decisions that people have and the dynamics of domestic and sexual violence, which really speaks to the work that the advocates have done over the course of the last 30 years to communicate clearly to people how limited people's choices are with regard to living in a violent relationship, what that causes a person to sort of have to struggle with in their life. And so I think it gives me great hope that our society is starting to finally really understand the dynamics of violence, the dynamics of trauma, and back to what Julia mentioned earlier with regard to the courts and the defense attorneys wanting to have the power and control. I think it's a recognition that the criminal justice system itself replicates a lot of the dynamics of a violent relationship, where once you get involved in that system, somebody tells you who you can talk to, tells you when you can use the restroom, how you can spend money, how you can spend your day. Those are the exact dynamics in a domestic violence relationship that get people involved in the criminal justice system in the first place. And it's frankly incredibly traumatizing for a system to sweep in and say, we're essentially replacing your abuser in terms of controlling every aspect of your life, but we're doing this for your good. Which again is the same kind of gaslighting that you get from an abusive partner. I'm doing this because it's good for you, right? And so I think as our society starts to wake up to that recognition that there is another better way to do this, that we can give people skills and strategies to actually be successful and to parent their children in their communities and save money. If the bottom line is all that matters, it's a lot cheaper to do restorative justice than it is to do just straight punitive justice. And so I'm hopeful that we're starting to wake up to that fact and create better policy in response.
So looking to the future, I'm very curious about, I started the show by talking about how things are not simple and people don't fit into boxes. And abuse is also not simple and also is not limited to sort of the tropes that a lot of us have in our minds about domestic violence. I myself have represented a lot of people who had suffered a lot of different forms of violent trauma that contributed to why they were there in court, but that might not have neatly fallen into a box of domestic violence, other forms of neighborhood violence, broader familial violence, but that had a lot of the same dynamics: coercion, control, feeling like one had no choices about one's actions. I'm wondering, Julia, do you think that in your groups, women are mothers, women are members of the community, women are deeply, deeply linked to other people who are experiencing the brunt impact of the system. Do you see a push in your work for broader acknowledgement of cycles of abuse and trauma beyond domestic violence in the system?
I think that we need legislation like this in order to force that type of consideration. I think that passing legislation like this, which is going to require an investigation and a consideration, will start to open the door for other considerations of, like you had talked about before, very complicated, complex lives. And it's not cookie cutter. It's not like we can't fit people and their situations into neat little boxes. But it is going to take requiring the system to look at these issues. And I think this is a starting point that as you know, we start learning more about domestic violence, as it becomes something that more people recognize and acknowledge, we can open that door for more consideration of other complicated factors.
Representative Williams, one more question for you. As we talk about how this is part of a broader movement and perhaps the seed of something that there is growing popular demand for, obviously when we look across the nation, where people are on policy and the policy surrounding trauma is really varied. I mean, there are DAs in this country still incarcerating survivors of abuse to force them to testify against their abusers when they don't want to. And I really heard you loud and clear when you talked about the system replicating the dynamic of abuse and re-traumatization. So I'm wondering, being now neck deep in HB 2825, if you have any advice for lawmakers elsewhere who are trying to pass similar reality-based reforms, but are coming up against opposition. What's the best way to measure this kind of change?
I think it's really important to be as broad as you can in your coalition building and to work closely with people who truly do understand the dynamics of violence on a variety of different levels. So if you're able to gather support from, coalitions in your state that serve survivors of violence, serve survivors' children, right? We have different perspectives depending on sort of where we've sat on that spectrum. And also continuing to talk to those people who have different perspectives, people who think that the criminal justice system really should isolate people and control every aspect of how they continue to move forward, so that we're able to identify sort of, every state has its own unique mix of laws to begin with. So we have to kind of figure out where's the right place to start making some positive movement. And a lot of times that does start with children or mothers who are victims. We have some sort of empathy for those groups already that's been built. So we can start there, and then we can build on the successes that we are able to make in those areas and continue to expand the conversation out, so that, in my ideal world, our justice system is really built on empathy and restorative justice, where we're giving people tools, and they're able to understand and be accountable for the crimes that they've committed and make amends in their communities, rather than just being locked away from their children and continuing to almost replicate the cycle of violence with the state as one of the actors.
I am going to take that imagery with me and that framework for analysis with me. Thank you both so much for joining us. It's been really eye-opening having you here today, and it's been a pleasure. And I hope that we can have you both back soon to update us on how change has gone in Oregon.
Thank you so much.
Thank you.
So across the country, we are in the midst of a really interesting time in the criminal legal system, where we have a system that's based in many ways on fear and retribution, facing a public demand for change that's based on reality, evidence, and public safety, common sense moves that make people safer at home. In Oregon, the reality is that a lot of women and a lot of people generally are in prison and in the system because of their own experience of abuse, because of their own survivorship, because of coercion, because of control. And it's so interesting what Representative Williams pointed out, which is that when someone who is in the system because of abuse gets there, all of the dynamics of the system replicate that abuse all over again. You're suddenly being told where you have to be, when you have to be there, when you can talk, when you can use the bathroom, who you're allowed to see, who you're not allowed to see, and sometimes even being violently held, harmed, or restrained. That's re-traumatizing, and that doesn't make anyone safer. We heard from both Julia and Representative Williams about the degree to which, given space and time to heal and reflect on what happened, there is the chance for restoration and transformation. And that's not the case when mandatory minimums and other hardline rules force the system and force judges to throw people into cages when they should be getting support and care to make a change. What's interesting to me here also is these are not extreme policies. These are not bleeding heart, wild, burn the prisons down policies. These are really sensible, reasonable, measured changes that both the representative and Ms. Yoshimoto were talking about. I think what's really the take home here is that this has to be a state change. As was pointed out, so much of criminal law is state by state. And perhaps in Oregon, we have a framework here for other states to do the same in bringing evidence of survivorship, bringing evidence of abuse, bringing evidence of trauma into the courtroom and really tailoring better solutions that are more likely to stop harm instead of just meting out punishment. The good thing about state change is that individuals can have more of an impact on it because states are small. Our nation is big, but our states are small. And that gives people who care about this, the 70% of people surveyed who very much want to see this evidence considered and better solutions rendered, have a chance to really have their own voices heard at the state level. So I hope you enjoyed this episode of The Appeal Live. We look forward to seeing you again soon. You can follow us on Facebook or Twitter. I'm Emily Galvan-Almanza. Thank you so much for joining us.